my name's Ben Rai. I'm the principal trademark attorney at Point & Partners, and I'm also the host of Export 101. And today it's one of my favorite episodes. Why is it my favorite episode? Because we're talking about intellectual property, which I love and I do every day, providing advice to small business owners, medium-sized businesses to large businesses. And I have a special guest today, my colleague at Point & Partners, Barry Meskin, and he's a patent attorney. And he has many, many years of advising business owners about protection. So to begin, Barry and I will each talk about our expertise. So myself, I'm a trademark specialist, and Barry's a patent specialist. So what is the difference between a trademark and a patent? Well, a trademark is branding. So you're protecting the name of your brand, whether it's a product, service, or a company name. And you can protect it under many classes. You can protect a logo, words, numbers. You can even trademark a scent if you want to. Things like Toblerone, when you see the chocolate in the stores, that's what we call a shape mark. So really, at the end of the day, if you've got a brand and you want to protect it, and you don't want a competitor to copy it, then you would obtain what we call a trademark. And Barry, can you tell us a little bit more about patents and what's that all about?
Yeah, sure, Ben. Thanks for that. So a patent is a legally enforceable right that is granted on a device, a substance, a method, or a process. And when it's granted, it gives the patent holder the exclusive commercial rights to use that invention. And we say that it's the exclusive right to exploit the invention. And that is, they actually get a monopoly for the invention that they come up with, which lasts typically up to 20 years for that new and inventive product.
Right. As like a trademark gives the legal rights to the trademark owner to exploit their brand as well in the marketplace, whether you might want to license it or not. And you've made a point with patents, there's a maximum of 20 years. With a trademark, if you obtain a trademark within the country that you register the trademark, you can actually renew it every 10 years forever until you don't want to renew it anymore. So I guess today what we want to talk about really is why would businesses that are looking to export want to look at intellectual property protection? Why is it that it's important that they consider intellectual property before they even consider launching that brand name into, let's say, the US market or their new invention to an overseas market? So I must start with you, Barry. Why would it that an inventor should consider it, considering that patents are quite expensive to obtain in the first place? But why is it important that they even consider it?
Yeah, sure. So this is a very common question, and it's completely understandable from the inventor's perspective. The most important thing that I find is that if you've spent a lot of time and money developing a product, it's really important to be able to stop other people from copying that. For example, if you've spent hundreds or tens of thousands of dollars, if you don't protect it by way of a patent application, then what will happen is if it's successful, competitors will just start to copy it, and there will be nothing that you can do to stop them from copying the invention. The other important aspect that we see is that in order to get investment, especially if you're working in a startup company and you're trying to get investment for that startup, it's really important when investors come along, they're going to ask, what is going to stop competitors from copying you? And a patent is one of those things that they look for. So those are the two most common things that we see from a patent perspective.
So from my understanding, if you obtain a patent in Australia and you're successful in obtaining a patent, but you don't actually apply for it, let's say in America or in the UK or in Singapore, and someone from that country sees your patent and sees that that product is selling really well, they can actually reproduce that product in America, Singapore, and the UK without any issue, without any legal ramifications for them?
Yeah, that's a really good point that you've raised. That most IP is jurisdictional, meaning that if you've got it in Australia but you choose not to apply in your overseas markets, that you lose the ability to protect it in those markets. So it is really important to have a think about where commercially people want to sell their products, where are the big markets for those products, and make sure that they file particularly a patent within the specified time limits in the country or countries that they want protection. Because like you mentioned, if you don't file the patent within that particular timeline, you lose the ability to ever be able to file that patent again. So, because once the information is out in the public domain,
yes,
it's available for everybody to use. And even if you are the one that came up with the invention, if you don't stick to those timelines and file within time, you won't be able to stop anybody else copying you, like you said.
Do you have any successful examples of a patent that has protected the invention and the owner of the patent has exploited around the world? I mean, there must be lots of technological products that are out there that have had a patent.
Yeah, look, there are plenty of kind of success stories and lots of kind of failures as well. I think the most common success story that everybody might be familiar with is Wi-Fi. You know, we have Wi-Fi in all our computers, in all our mobile phones, iPads, etc.
And it was also developed in Australia, wasn't it? Wi-Fi.
Well, that's right.
Yes.
Now, the CSIRO developed part of the Wi-Fi technology. They patented their technology. And so for every device now that's manufactured with Wi-Fi, the CSIRO gets a royalty because they developed the technology. So that's an example of a really successful product that everybody knows that was patented and is commercially very successful.
And what if they didn't actually patent it, Barry? What would have happened? That they wouldn't have received anything for their invention.
They wouldn't have received any royalties. And a really good example of a failure in that respect is if you think of the power boards that we all have at home.
Yes.
You like double adapters, you plug it into your power point, and then you have 3 or 4 additional power points. Well, that was actually developed also in Australia. But that wasn't patented. So
oops.
Because the amount of that was released, huge commercial success, and everybody thought, wow, what a great product. And now you look around the supermarkets or the hardware stores, and there are hundreds of different brands of power boards, and no one really owns the rights to those anymore because there wasn't a patent filed.
So I think if you don't have a patent and you've released a product, it could also be that someone may buy that product from overseas or wherever, and they can re-engineer it and reproduce it. So without a patent, you can't stop that person from reverse engineering that product.
Yeah, that's right, exactly. And it's always, if you think about the product development cycle, it's always a lot easier to copy a product that's working already, and a lot cheaper to do that than to develop the product in the first place, because it's a bit of an unknown when you're going through that product development cycle.
That's right.
So again, so if you don't protect it, then you're just you're letting anybody just copy you. And for them, it means they're going to be able to develop their competitive product at a much lower cost, because they know what your product looks like, they know how it works, and they can just give it to a factory to reverse engineer. And if you don't have the patent, then again, there's nothing you can do.
About it, Well, that's a great segue into trademarks. It's exactly the same thing. If you've spent all your time and energy to create a brand, and we've also got to remember that brands start very small. No brand has ever just launched in the marketplace without any effort or sweat equity. before they become a very big, brand in the marketplace. I often say Steve Jobs started Apple in his garage. Everyone knows that story. And he came up with Apple computers with his co-inventor. And if they hadn't actually trademarked Apple computers, the other competitors in the marketplace could have piggybacked on the brand equity of good quality, stylish products, great servicing, great store layout, customer service. So without a trademark, brand Apple would have been exploited by others in the marketplace, especially maybe their competitors, because what's easy to do, as you said, is to actually piggyback on somebody else's hard work and brand. And without a trademark, you're not legally have any grounds to actually stop the other person from using that brand. And with trademarks as well, like patents, you can license it out to others to use it. You can also trademark for various classes. I've just watched the movie Elvis recently, and it got me thinking about I wonder how many Elvis trademarks are out there in the world.
Yeah.
And I did look it up, and yes, it's really, really important that because Elvis, when he became popular, there was lots of merchandising. And so without them owning their trademarks, there could be a lot of, providers out there that are in merchandising that could exploit the Elvis Presley brand in the marketplace. So that's why I think this topic is really important for exporters. So when you think about exporters, it's actually even harder than just if someone was starting a business in Australia. Imagine if they have a trademark or a patent infringement that they didn't actually have their own protection, and they've actually launched a product, whether it's, let's say in the States, and they didn't actually do the due diligence of checking about whether the product was unique enough or the brand name that they've chosen is unique before launching it. Because if you go to those countries and you find that you are infringing, imagine the product recall or the lawsuits that will be flying around in the US, considering the US is the country that likes to I think protect their patch and their business. So it's really important. Do you agree, Barry, that they need to?
Absolutely, yeah. So it's really important, like you've said, before you launch in a particular country, to check the databases in that country to make sure that the trademark or the brand name that you're going to use is available, like you've said. And the same thing with patents. It's important to do a patent search before you launch a product to make sure that you're not infringing on anybody else's product by actually launching your own product. And I think that's something that, especially, like you said, there are countries outside of Australia or that are much more litigious than we are in Australia, and they will be absolutely on you with a lawsuit if you're infringing their rights. So it's really important to do that groundwork beforehand. So and
I believe another benefit of obtaining intellectual property protection is that once you obtain it, you can actually record your registration with customs, and customs could monitor whether the goods that are traveling through the border, the country borders, are infringing on either a trademark or a patent.
Yeah, that's right, and that's really actually a really good point, because what we've seen a lot, especially trademarks is one aspect of that, patents as well. If you have a really good relationship with customs, you can tell them where the products are going to ship from. You're going to tell them what you can give them pointers as to what's a genuine product, what is the brand on a proper product look like, what quality should they expect from your like a real genuine product. And once they get comfortable with that, the customs are really good at identifying those fake shipments. So if it's coming from the wrong if it's coming from a factory somewhere else, if you say, look, my product's only coming from Australia and the shipment comes from somewhere else, then they can immediately flag it. So really important to read.
I read, I think it was maybe 5 years ago, that a shipment of Wheaties, it's a cereal from the UK, a shipment, a full container load was stopped on the New Zealand border. The container was stopped at the New Zealand border because Sanitarian, who owns Weet-Bix, said Wheaties is infringing on their trademark in New Zealand. And because Wheaties actually didn't have a trademark in New Zealand, that container load of cereal just sat on the docks into the court case, or the settlement of the trademark infringement was resolved. And what I felt sorry for was really for the retailer who purchased it. They were stuck in the middle. They thought that it was okay for them to ship it to New Zealand, but unfortunately, they didn't actually check if that product was legally able to enter the country in New Zealand. So that's a great example, actually, where of exporting from UK to New Zealand, where shipments can be stopped rather than the docks and sit there.
Yeah, and that's a really good point, and I think, and it's for anybody exporting or importing, speaking to an attorney before they've done anything.
That's
speaking to someone like you for trademarks or an attorney is really important, just to make sure that they don't get stuck in that situation where that person who imported the Wheaties probably had to pay for the Wheaties before it was shipped, and they've probably lost out all that money. Whereas it's always a lot cheaper to do some due diligence beforehand, make sure that everything's fine, and not have to incur the loss of not being able to import it, or maybe the Wheaties going bad on the at the docks.
Well, I think the worst part of the whole the shipment on the border would be that you can't send it back because it's expensive. I mean, especially now, freight is so expensive. But you've actually got to destroy the product as part of the infringement. So the person that actually shipped it, whether it's overseas or into the country, if they're found infringing, they've actually got to destroy it or return it to the origin of where they purchased it from. And I think both options are not desirable. Really, they should really be checking with experts like us to just have a chat and make sure that before they spend too much money, that those products are legally able to enter the
exactly.
The country. Yeah. So, is there any other points would you like to make for any exporter that are other manufacturers or looking to export products from Australia?
Yeah, so I think it's really important for most businesses to have a look at whether they can get patents and trademark protection. Obviously, trademarks is relevant to every single product or service you can export. Patents is more relevant to anybody that's manufacturing or producing physical products, but it is really also important in other service industries such as SaaS products, which we're finding are becoming much more popular now. So where they're using kind of a software and they're selling that as a service, and that's really being exported anyway, even if it's not a physical product. It's still an export, and in most cases you can still get some form of patent protection on that. And I think you also raised another really important point, is that if you do have a patent or a trademark, and you can actually license that overseas if you have the particular IP registered in the country. So if you're looking at appointing country managers or partners in each particular country, having the IP registered allows you to generate a revenue stream as well. So it might be licensing the IP to them, and that can create a real strong revenue stream, and also, again, like we said before, just stop the competitors.
And in both our instances, businesses can actually submit a patent application themselves or even a trademark application themselves. However, by looking at exporting, it actually gets a bit more complicated, because in Australia, at least, if you start a business, it's very clear cut who is producing the product and who's selling the product. But once you start exporting, you may not be on the ground there. And as you said, Barry, you would need licensing agreements of some sort to ensure that there is a track recording of evidence of use of the brand. Because in the case of trademarks anyway, you use it or you lose it. And I don't think that rule applies with patents, but it's still very important to ensure that the rightful owner is recorded on the patent or the trademark to make sure that it's valid.
Yeah, absolutely. So for patents, there isn't really a use it or lose it clause, the same as trademarks. But the important thing I think you mentioned there is it can be sometimes deceptively easy for people to file their own applications, and you go to the website and you think, oh, there's a form, I'll fill in something and do it. And I think we can both understand it's often where this comes undone is when you actually need the patent or the trademark. If it wasn't filed correctly in the first place, or you took the wrong box, or you had the wrong information in there, well, it almost becomes worthless because it just hasn't been filed correctly. And in order for it to be valid, you should not try and take too many shortcuts. If you're spending so much money and trying to develop a market, just get it done properly. And I think that applies to a lot of different areas of the business. Just do it properly so that the business owner can just focus on what they need to do, which is selling the product and getting
that's correct.
finding sales, rather than trying to find save a little bit of money here or there, where they're likely just to cause themselves a bit more damage than if they just got a professional to do it.
And with intellectual property, it's something that has to be planned and thought through. With trademarks especially, it can take 8 months in Australia, but longer in America or in other countries. I know in the UK, it may be about the same time as 8 months, but I did a trademark, I think in Malaysia, that took nearly 3 years. So each country has different time periods where they process it. And I think, what is an average patent registered? So what's the time period?
So for patents, it's actually much longer than trademarks. So what we find is there's a lot more steps in a patent application, and between filing the first patent application, which is generally started in Australia, and then we use international conventions to file overseas in overseas countries, you're looking normally at about 3 to 4 years before you actually get a granted patent. So you do need to plan well ahead of launching the product. But the thing we tell clients is, once the patent's granted, it's retrospective. So the rights start from the time that we file the application, which I think is similar to trademark. But even though it takes a couple of months, or in the case of a patent, a number of years, the rights start from the time of filing. So you don't have to wait for that time period necessarily to lapse to launch. But again, the forward planning and the searching beforehand and making sure that you're not infringing on anybody else's rights is really important to make sure that you've got that ability to sell the product, but then also you've got the runway to get the patent or the trademark registered before you need it effectively.
I do want to bring up one important point, the difference between a patent and a trademark. A patent, you can't actually launch anything, because if you do launch anything before you apply, you actually invalidate like your own patent? Is that
Yeah,
correct, Barry?
that's correct. So it's really important to keep the invention or the product secret until you apply. So
And that's even
effectively,
publishing it on the internet, is that right?
that's
Like,
that's publishing on the internet, because the way the patent system works is you can only get a patent for new knowledge. And the moment you publish it or put it on the internet or tell your friends down at the pub about it or start selling it, it's deemed to be in the public. And even though you invented it, once it's in the public, you can no longer patent it. So it's really important to get your, what we call the priority date, which is the filing date of the patent, has to be before you publicly launch it or put it on the website. So, and if you don't do that, you just risk you risk losing the ability to obtain the patent.
Yeah. Whereas with trademarks, you can file pretty much any time, but we all, of course, suggest you file it at the beginning of your business, not wait for years. But with trademarks, you can launch the product and you can apply for the trademark letter even if you publish the name of the brand in the marketplace. So those are the two key differences, that with a trademark, it doesn't have to be secret, it can be launched straight away. But we don't actually advise that you actually have to do your research as well to ensure that it's unique. I mean, that's the main thing. In both cases, it's got to be unique, whether it's the brand or the invention. So, protecting intellectual property can be expensive. Well, it is expensive. And in further episodes, we will be having special guests talking about some grants the Australian government is offering to small business owners, or just business owners in general, that are looking to export their products. And I look forward to seeing you then. Thank you very much for joining us for this intellectual property segment.